Morning, Mr. Chapman.
Good morning, Your Honor.
Good to see you back.
It's good to be back.
Okay. Go ahead when you're ready.
Thank you. Is this Mr. Brown?
Yes, sir.
In each of these matters, Mr. Brown is here today after failing to appear before referee Nets on June 7th, 2019. In the 08 case, bond is currently set at $1,599. This is the second bench warrant. In the 94 case, bond is currently $4,418. This is the fourth bench warrant. Front of the court does not have any employment information. Last payment made on these accounts was in November of 2020. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on September 13th, 2023 at 8:45 a.m. before this court.
Mr. Brown, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on September 13, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Not at this high a bond. No, sir.
Okay. Are you working?
I just started a company, actually, myself.
Okay, so you're self-employed.
I just started it, so I mean, it's kind of
Okay.
just taking off kind of thing.
Okay, well, court does note that you have had 4 bench warrants in the one case, 2 in the other. You have not paid in going on 3 years. And you have a substantial arrearage, so the court's taking all of that into consideration. In the first case, the 08 case, the court will set your bond in the amount of $200. And in the 94 case, the court will set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
I do not, sir.
Okay, thank you. You're excused. Have a good day.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of the defendant. Good morning to all of you. The court will note that this matter is before the court on the defendant's motion to hold plaintiff in contempt. The court will note that the court did enter an order back on October 13, 2022, granting custody of Austin to the defendant in this particular matter. And the court did on August 15, 2023, enter an ex parte order requiring that the plaintiff return Austin to the defendant. Do note that Ms. Johnson has filed an answer. I've reviewed that answer. Ms. McNiff, you can proceed.
Your Honor, currently Austin is still in Michigan. Ms. Johnson has enrolled him in Lakeview High School. It's our understanding that he's been attending Lakeview High School. We find this completely unacceptable. Also, there's been a CPS complaint that was filed in Virginia. There's a letter in the mail today to Mr. Ungaro. We believe that will be a letter indicating that the abuse that was alleged is not substantiated. We would note that since being in Mr. Ungaro's custody, Austin has done particularly well in school. He's passed his classes. He was participating in football last year. He's done very well. Over the summer, things deteriorated. Our belief is that Ms. Johnson was not requiring Austin to take his antidepressant medications, and that's caused a certain amount of mental instability with Austin. But we are asking that this court require that Ms. Johnson return Austin to Mr. Ungaro immediately and hold her in contempt for her failure to send him back to Virginia when she was required to do so. Okay.
Ms. Johnson, your response.
I would like for the whole thing to be dismissed based on MCR 2.105. Any type of motion for improper service, it must be personally served. It's a motion for contempt for disobeying a court order, and I was not given that due process of law. It was mailed, but it was not done as a personal service. It cannot be done the same way as it was before. It has to be a personal service.
Okay, Ms. McNiff, what's your response?
It's true. We were not able to serve Ms. Johnson personally. We're not completely sure where she is staying. She's been staying with both a boyfriend and at the home in Battle Creek. She's been away quite a bit. However, regardless, Austin needs to be returned. This court's already filed or already signed an ex parte order requiring Austin's return. And we're asking for that relief.
Okay,
Your Honor,
go ahead.
in addition, besides that, I have lived at this home for 7 years. I own my home. I've never changed my address. I have gotten all of my mail here. I've never missed court unless it was sent to me by email, and I missed a deposition because I was improperly served before. And also in addition to this, they have sent this motion to Friend's house. And we are under court order by your court order to not talk about this case outside of court. And she sent it to my fiance's home. So that he had this personal information on me. And I think it's a form of intimidation and harassment. And this is not the first time that this has happened. This is the fourth improper service to myself. And I believe that I deserve due process of a law, and I would like for it to be dismissed with prejudice because this is the fourth time.
Okay, well,
We sent it to the fiance's house. We sent it to her home of record. And we emailed it just to ensure that she was able to obtain and see this motion before in time so that she could appear.
okay, well, in view of that, what happens, the court is going to order that, again, proper service be made, and the court will order that, again, we'll have a hearing because clearly Ms. Johnson has disputed the contempt, but the court does note that Ms. Johnson has filed some motions as well with the referee. I know those were supposed to take place today. The referee has asked that those be renoticed. The court is going to have those renoticed before me. I'm not going to have these. I'm not going to have people engage in forum shopping going between referees and judges. I want to hear everything at one time. And so I'll have those renoticed before me, and we will address those at an evidentiary hearing. The court will note in Ms. Johnson's response that there is a lot of reasons she's claiming that Austin was not returned first. She's claiming that, again, that there was a CPS investigation, which obviously has been acknowledged. We'll get the report on that before we have a hearing, and we'll be able to see what they're doing. She's also alleged that, again, she was not aware of road construction, which caused delay in getting him to the airport. The court would only note that everybody in Southwest Michigan knows that there's construction along I-94 and that it's delayed, et cetera. So that's not basically a valid argument. The court does note she alleges as well that Austin had some issues with not getting his boarding pass. Well, that's occasion because you didn't get him to the airport in time to get to check in, et cetera. So the court doesn't hold a lot of weight with that response as well.
Your Honor.
No, ma'am, I'm done with you. I'm ruling on this matter. In this matter as well, you've brought up the issue of the physical assault. Court finds it very suspect that didn't happen until after, at the time that he was being returned. You had him this summer. And we don't get any allegations of assault until the very end when he isn't returned. Ma'am, it's your responsibility to return him as a parent, and you have that responsibility to do so. The court is giving you 1 week through September 11th to have him returned. If he is not returned, then I'm ordering that you report to the Calhoun County Jail for incarceration until such time as Austin is returned. So, Ms. McNiff, you can prepare that order and submit it to the court under a 7-day order. The court will order Ms. Johnson that you remain incarcerated until Austin is returned at that particular point. And then we will have a hearing on the issues of contempt and Ms. Johnson's issues and her motions as soon as she gets those filed as well. So that will be the order of the court. The court will end this matter at 9:37 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Good.
We do not have the defendant in this case. Have you had any contact?
No, I sent him the letter that was attached to my motion. I also sent him a detailed cover letter when I filed my motion outlining what it was, when the hearing was, and Zoom instructions. I called him Friday, but left a voicemail. He didn't answer.
Yeah, he probably saw it was you, Mr. Umloff.
That very well could be.
Court will note the appearance of Mr. Umloff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to show cause to hold defendant in contempt. Mr. Umloff, as I review this, I think probably an easier way, because obviously there's obviously there's not any way we're going to be able to force him to execute a deed. Why couldn't we just do an ordering the transfer of the property to your client, and that would make it cleaner, and he could file that with the Register of Deeds?
That would be fine with me, Your Honor.
Okay, do that. Let's make sure that the order does include the legal description, or the Register of Deeds isn't going to have much use for it at that point. I do note that you had requested costs and fees in this matter as well. What are your fees?
In reviewing this, I have $875 in fees and then a $20 motion fee.
Court would grant you the sum of $895 in costs and fees, which will be payable within 45 days of today's date. And you can include that in the order. And anything else, Mr. Unlock?
No, Your Honor. Thank you.
Okay, thank you. The court will conclude this matter then at 9:41 a.m. Court will note that while we've been doing this, the defendant has still not appeared. And that will conclude this hearing. Court will note the appearance of Mr. Todd on behalf of plaintiff and Mr. Toth on behalf of defendant. This matter is before the court on the defendant's objection to the plaintiff's order following the August 7, 2023 hearing. I do note that Mr. Toth has argued that the plaintiff's order failed to address legal custody. Mr. Toth, just for your edification, if a court does not differentiate when I grant custody, then the intent is that it's both legal and physical custody. If I just grant custody, I don't differentiate, then again, that it's both. So
I understand, Your Honor. I did not attend the hearing. I looked at the replay and was not able to determine what the intent was. I do know now, and so obviously that will stand. From the other perspective, Your Honor, unfortunately, the parties have not been communicating well. That should be no surprise. And I think that our order provides specificity as to who's going to exercise which particular holiday. It simply avoids confusion at a time when it shouldn't exist. Our order identifies whether the plaintiff or the defendant has a particular holiday, whereas the order that was proposed simply says to alternate.
okay. Well, I guess do it this way: is who had the child yesterday? That was Labor Day. So
She did. Plaintiff.
okay, well, if plaintiff had the child on Labor Day, then we'll alternate from that holiday. Is that what your order provides, Mr. Toth?
Our order simply, let me take a quick look, Your Honor. It's an odd year. No, as a matter of fact, it's not. We're in an odd year, and the proposed order identified the defendant, so we'll have to flip-flop that.
But in Your Honor, the court didn't specify how that alternation would occur. I mean, I believe my order is appropriate. It indicates, exactly what the court ordered in terms of legal and physical custody just being sold to plaintiff and then alternating. I believe the parties should be able to alternate simply based off of that pattern, with plaintiff starting on Labor Day. So then, he would end up having Thanksgiving weekend going from there.
Okay, why don't we do this? We can enter Mr. Todd's order, but Mr. Toth, why don't you do a separate order acknowledging that the plaintiff had Labor Day and that we're alternating from that date, so there isn't any confusion in the future.
I will do so, Your Honor. Thank you.
Okay. Thank you. We'll end this matter at 10:03 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
10:05
Why does he
a.m.
get more?
Court will note the appearance of Mr. Todd on behalf of plaintiff, Mr. Toth on behalf of defendant. This matter is before the court on the plaintiff's objection to order. Mr. Todd.
Thank you, Your Honor. Your Honor, I reviewed the hearing multiple times, and we actually went back and forth a few times. I think the only concern, I believe, without putting words into Mr. Toth's mouth, is the parenting time scheduling provision. They did send a revised order. I believe that they agreed to all revisions outside of what I indicated in parenting time schedule. The court stated in essence that Ms. Reynolds couldn't schedule any events during Mr. Reynolds' time. And it was a little bit confusing whether or not that was actually supposed to be in the order at all. However, I believe that was Ditka. I mean, it would be certainly very strange for the court to not order that both parties couldn't schedule anything during the other parent's time. And so I believe that was the intent of the court. And I believe outside of that, all other issues contained within my proposed order have been agreed upon.
Okay. Mr. Toth, obviously, I think we were addressing the issues about the plaintiff scheduling. So that's why the court addressed it in that way. There were no complaints about the defendant scheduling during her time, and that's why I didn't include that. Mr. Toth, do you have any problem with making it joint that both parties would not schedule events on the other party's time?
Well, Your Honor, I have, if that was the court's intent, I obviously would have no problem with it. I've looked at the same tape again, and I can't discern, Your Honor, the hearing was not that long ago. So if the court intended that applied to both parties, then I have no
Mr.
objection.
Toth, I didn't.
Okay.
As I stated, we were only addressing what plaintiff was doing. I'm just saying, Mr. Todd has brought that up. If that's not an objection, or if you don't have an issue with that, we could make it mutual, but we didn't address it. It wasn't in the order, so I wouldn't intend to do that unless you just want to placate Mr. Todd is all.
Well, that's not a primary motivation, Your Honor. I don't think it's been a problem with my client. I don't see why that prohibition should be included to include him. It's never been a problem.
Then we won't do it, Mr. Toth. I would just
thank you.
Does the rest of, as Mr. Todd states, the rest of his orders that now address your objections?
Well, limited to the makeup, what I think Mr. Todd has done is he's kind of amplified exactly what is meant with the makeup. Makeup parenting times to occur within the next 6 months and made up in according with equal times missed. He's concerned that it doesn't specify that it would not include overnights. I don't think it's necessary, but I have no objection to it. Because I think it says the same thing.
Okay. Well, the intent, obviously, if it was a Wednesday that was missed, then he would only get the standard 4 to 8 on Wednesday, not an overnight.
Correct.
Because I said it would be comparable to the time that was missed. So I think that, at least now, Mr. Toth, that you think that the order comports with what your belief is.
Yes.
Okay. Court will then enter the order as submitted and as revised by Mr. Todd, and hopefully that will resolve the final issues. The court will end this hearing.
Excuse me, Your Honor, other than I thought it was that the first sentence or the first component of the order regarding makeup, it would be limited to the plaintiff as opposed to the parties.
Okay. Mr. Todd, why don't you change that and resubmit the order under 7-day? We'll get it entered.
Here, I'm happy to, and I apologize. I'm not trying to belabor the issue, but I don't think it's the court's intention to indicate that Mr. Moresh can schedule things during Miss Reynolds' time. And
there's no intent on the court to allow him because I was silent on that. But the fact is, as I said, it was the plaintiff that the complaint was being made against. So we addressed that at the hearing. We didn't address anything concerning the defendant schedule anything. So I guess if that happens, then you can always file a motion and we'll address it at that time.
Absolutely.
Okay.
Thank you, Your Honor.
Thank you.
Thank you, Your
On
Honor.
this matter at 10:09 a.m. is read on behalf of plaintiff, Mr. Todd on behalf of defendant. And just Ms. Reed, because you confused me initially, you've entitled this as defendant's motion to modify temporary custody's support for phone call, for schedule, for show cause, and psychological assessments. And then you did in the preamble reference that you referred to effectively plaintiff as defendant. So I assume that this is actually plaintiff's motion, not defendant's.
That is correct, Your Honor. That is my mistake.
Okay, go ahead.
So school has started. We have a couple of issues. One of those being parenting time. Right now, my client has parenting time Friday at 6 p.m. until Monday at 8 a.m. and the standard midweek parenting time on Wednesdays. The Wednesday parenting time, and discussing it with my client, does not afford a reasonable parenting time to be enjoyed on that Wednesday due to the distance between the parties and the amount of travel that would be placed on the child. So what we're requesting is that the Wednesday parenting time not happen, and then that Sunday parenting time that would happen twice per month on every other weekend be moved to an additional Friday and Saturday parenting time to alleviate any issues that might come up during school in the winter and transporting the child to a Monday morning class, as she would now have to wake up at least an hour and a half earlier to get to school on time on Monday. That's an additional more time that she would have to wake up early once winter hits to make sure that she gets to school on time. This request would match that of my client's other child, Isabel, in Kent County, who he has parenting time with 3 weekends per month, except for the last weekend. And it does not change the overnights, as we are taking away the 2 Sundays and then moving it to an additional weekend. So the number of overnights isn't changing. The amount of parenting time isn't changing. We're just moving it from Sunday overnights, and we're moving that Wednesday to an additional weekend. And this is what the status quo of what the parties have been doing this additional year. And if we have to go to an evidentiary hearing, we have multiple witnesses that will testify that this is what the parties have been doing. So that's our first request, is the modification of that parenting time. Our second request is for a phone call schedule, as prior to the defendant being served with our initial pleadings, Faye was contacting my client almost every day with either phone calls or text messages, and there was an open line of communication. After she was served, she denied all contact with my client for about a month, and my client has been repeatedly reaching out, trying to make phone calls to his child, and it's always an excuse. It's either she's with friends, she's too busy, she doesn't want to, and now we're getting false allegations that the child's afraid of him, which is completely not true. She runs to him during parenting time, and her phone is actually turned off during defendant's parenting time. So we're requesting a set phone call schedule so that he can continue that normal relationship that he had with his daughter prior to the defendant being served. And then we have an issue regarding a week in the summer where my client was denied parenting time due to the alternating week schedule that plaintiff selected, or defendant selected, as she selected that she wanted the first week of summer break. So due to their alternating schedule, he was supposed to have parenting time July 21st to July 28th. He repeatedly tried to reach out to defendant to discuss this over Our Family Wizard. She did not respond. I do believe he tried to reach out for a couple of weeks regarding this issue to try and make arrangements for this parenting time. He reached out to her outside of the Our Family Wizard app at least once or twice, because she refused to open the Our Family Wizard app, was ignoring all of his messages. And when she finally did respond, it was like the day before parenting time was supposed to start. And she said, nope, you're not getting that parenting time. It's my parenting time. So he's requesting that week.
Well, Ms. Reed, as I think Mr. Todd has filed a response, that if your client would have got what he wanted, wouldn't he have had 2 weeks consecutively then?
Three.
It would have been 2 weeks.
Great.
Okay, but if we're alternating every week, how can he have 2 weeks and comply with the order then?
Well, it was our position that he was going to get that additional week because he's supposed to have Faye 1 week and then Izzy and Faye the next week.
Okay, I guess I don't understand that, so you'll have to enlighten me, but go ahead.
So he's requesting that additional week of makeup because they were alternating weeks. And he was also supposed to get that additional week with Faye and Izzy together, pursuant to the Kent County schedule.
I don't care about Kent County schedule at all. This is my order. I'm not going to adjust things to accommodate Kent County schedule.
At a prior hearing, when this temporary order was put in place, it was specifically mentioned that parenting time would be following the Kent County schedule as much as possible.
Okay, but if we're alternating weeks and Kent County does something different, I expect that you would follow my order, which says alternating weeks. If Kent County says they put in some random day, I'm not going to enforce that. So I said that basically that we would attempt to accommodate so that the kids could be together, but I'm not going to alternate what the schedule would be, just because of a different order. Okay. So go ahead.
And then our final issue has to do with the psychological assessment that was ordered in the temporary order. Both myself and my client reached out to Dr. Haugen's office before we filed this motion, and Dr. Haugen's office indicated that at that time, the defendant had not scheduled her psychological assessment that was previously ordered, and that's why we included it in this motion. Now we understand it was scheduled for in the next couple of weeks, but we still have concerns that because of the delay in her scheduling that, we're not going to have the assessments back in time for mediation at the end of the month.
Okay. Mr. Todd, what's your response?
Thank you, Your Honor. In relation to the proposed modification of parenting time, nothing has changed since the court's initial order. School has started, and I fail to understand how this would not modify the number of overnights. The Wednesday is intended to be a midweek visit. It states clearly in the order, Wednesday from 4 p.m. until 8 p.m. If he got 2 additional overnights per month, then that would certainly increase the total number of overnights. So I don't understand how that's alleged. But regardless, there's nothing within the order indicating that he needs to exercise that parenting time at home. It's not uncommon for this schedule, and I believe the court generally prefers this schedule. And so he can go and he can have dinner or whatever the case is. Additionally, we do believe it's a little bit disingenuous that the specific times that were enumerated for Mr. Weller were not included in the initial allegation. And we believe that the court's response is appropriate in that it's not, we followed specifically the parenting time he requested, and every other week did not fit with that. He got exactly the parenting time we believe he was entitled to. In terms of the phone call, the phone is on for the child when she is with my client. She has her own phone that the plaintiff paid for, and she has her own phone that the defendant paid for. And during his time, he's supposed to have the phone on when the child's with him. During her time, the phone is on when the child's with her. And she doesn't listen to any of the conversations that happen with the child. The phone is on and the child's well within her right to call. My client doesn't do anything with that. Prior to this occurring, at best, the child contacted him once a week. However, beyond that, the defendant has, or the plaintiff has actually violated the order by reaching out to my client by 4 different numbers, 3 separate times, totally violating the order, not following our family wizard, and simply indicating that she hasn't consented to some proposed modification that Mr. Weller wants isn't sufficient to hold her in contempt when she's following the order. In terms of the request for the psychological evaluation, one, I don't believe it's customary for Dr. Haugen's office to disclose when an appointment has or has not been scheduled, because that would be a HIPAA violation. But beyond that, Ms. Morley does have an alternate last name, Tyree, so possibly there was some confusion there. However, that appointment is scheduled, and Mr. Weller's appointment was actually not scheduled to happen prior to this motion being filed. So we don't believe anything should change. And we believe that this is, in fact, kind of another issue of harassing my client. Nothing's changed since the temporary order. There's nothing new which would warrant a modification of parenting time. There's no good cause or a change in circumstances having a significant negative impact on the child. There is no viable change or no viable information indicating my client's not allowed phone contact with the child. We believe that that's totally inaccurate. The child has the ability to call plaintiff if he wants. She has fully complied with the parenting time schedule. And as the court, I believe, opinion is correct, she has contacted Dr. Haugen's office, and that is scheduled. And he's the one violating the order by sending her multiple texts. We believe that this should be denied in total, and we are respectfully requesting attorney fees for having to defend this motion.
Okay, thank you. Anything else, Ms. Reed?
Just that, Your Honor, this is an ongoing issue, and my client did reach out to the defendant outside of the Our Family Wizard app because she went weeks without responding or even opening the Our Family Wizard app, and he was trying to make sure that she was getting the messages. There wasn't any sort of technical difficulty. And once she did actually open the app and respond, he went right back to using the Our Family Wizard. So it's not that he's intentionally violating, he's trying to communicate, and the defendant is not effectively using the Our Family Wizard app. We believe that the change in circumstance or a proper cause, in this case, to modify parenting time, is appropriate and in the best interest of the minor child to alleviate that travel, and it does not increase the number of overnights. We're taking away the Sunday overnights, that's 2 overnights per month, and changing them to a different weekend.
Thank you. Well, in this particular matter, the court, and reading the pleadings as well as hearing argument today, the court's convinced that there is no proper cause or change in circumstances to modify parenting time in this matter, so the court will deny that request. That obviously the midweek is a midweek, and if a person can't exercise that, then they simply forfeit that. There's ways, obviously, I know there's a distance between the homes. You can't travel that, but typically parents will travel the distance to have dinner with the children or do something in that particular locale so that they can be returned in time without having to travel back and forth to the homes when there's a particular distance. So that can be accomplished if you want to do so. And if not, then simply that would be forfeited. as it relates to the calls, obviously, as Mr. Todd states, that again, the phones are on when it's the child is with the other parent, and that's appropriate, so they can be called. What the court will do is order, at least on the phone calls, as it relates to Mr. Weller, that he would be entitled to call the child on Tuesdays and Thursdays at 7:00 p.m. The child would be made available at that time. If there's other times that they want to communicate or the child wants to communicate, that's fine. But it'll happen no less than those Tuesday and Thursdays at 7 p.m. I do note that parties had not addressed the issue, but there was the issue on support brought up concerning the VA disability payments. And obviously, with that, that should have been included in the support calculation. I think that was stated in the pleadings, at least $2,293.39. The court would order that, in fact, the support would be calculated by the attorneys to take into account that sum, and that modification would go back to the June 16, 2023 order. With that, I don't find any basis to hold either of the parties in contempt in this matter. I note that, again, at the start of a case, sometimes things are confusing and it's hard to get the parties to coordinate everything, but I don't find any basis for contempt in any way. So with that, I'll leave it up to you, Ms. Reed. It was your motion. You can file the order. I'm not going to award attorney fees at this time. So thank you.
Regarding the phone calls, Your Honor, can we do Tuesdays and Thursdays at 7 p.m.? That's when my client has his other child to do three-way phone calls.
I said Tuesday and Thursday at 7 p.m.
And I'm requesting Tuesday and Wednesday.
Oh, well, Wednesday he would potentially have the child, wouldn't he?
Yeah.
Well, it's 7 p.m. and then they would be traveling because the exchange is at 8.
Your Honor,
Not on Wednesday. It's 4 to 8. It's a midweek.
Okay, well, we'll leave it at Tuesdays and Thursdays.
Okay. Anything else, Mr. Todd? You're looking quizzically, and
nothing for you, Your Honor. No,
okay. Thank you.
Absolutely.
Court will end this matter at 10:26 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
10:28 a.m.
Court will note the appearance of Ms. Lawrence on behalf of the plaintiff, Mr. Baranski on behalf of the defendant. This matter is before the court on the plaintiff's motion for custody support parenting time. Ms. Lawrence, and you're muted. Okay, great.
Good morning, Your Honor.
Good
Thank
morning.
you. We did file a motion for custody support and parenting time. We are asking right now for Mr. Garrison to exercise parenting time every other weekend. He has been exercising parenting time every single weekend, and my client would like some weekend time with her son when she's not working and he's not at school. We are asking also for child support. It's difficult for me, Your Honor, to make a specific ask this morning because we don't have income information from Mr. Garrison.
Okay. Okay, well, I can take care of that easy. I'll order that the parties would, within 7 days of today's date, exchange all information concerning their incomes. So we'll put that in the that order as well. Mr. Baranski, your response.
Your Honor, yeah, we have the financial disclosures. We can email that to council right now. It's not a problem. We can get that done. I think what the request really has been, but I didn't even bother to respond, is that I know the court's aware. The old days we used to just ask the court for referral, fill out the form, check the box, and if it did, we ex parte. So I thought that we could just agree to have the front of the court look into this. That's what my understanding was.
I don't just regularly grant front of the court investigation support. You can take the income and you can calculate it as easily as the front of the court can. Quite frankly,
I wasn't.
They're so busy. I can't put more, I guess you say unnecessary matters before them.
Oh, no, Your Honor, I don't have any problem. The attorney's doing the child support. We've got the formula. What I'm talking about, the issues of the custody and the parenting time.
And regularly, I do not just do it as a matter of course. If it comes up and a court finds that it's necessary based on the pleadings or arguments, I'll do it. But it's rare when we just don't regularly send those for review by the front of the court.
I see. Yeah. I think both counsel are from out of county and we're used to procedures where everything automatically goes to the front of the court. Of course, those are bigger cities with more money. Okay, that's good to know. So what could the court instruct us as to what is the policy with the court as far as the custody What is?
Well, what the court will do, again, I'll give you, based upon what you stated, the court will grant joint legal custody. It does appear that the plaintiff does have physical, if you would. I mean, the defendant has had the child on basically every weekend. I understand her desire to have some weekends. So what the court's going to do is grant to the defendant alternating weekends. And then in the alternating weeks, the court would give him parenting time from Wednesday at 6:00 p.m. to Friday at 6:00 p.m., as well as alternating holidays. So he continues to get his time that he would have, but just not every weekend.
Very good.
And a court would order, of course, support consistent with the child support guidelines. And that would be to the notice of the motion, which would take that to July 30, 2023 for purposes of support being effective. Anything else, Ms. Lawrence?
Your Honor, I just want to clarify. I just want to make sure that Mr. Garrison is going to be able on those Wednesday to Friday days to transport Franklin to school.
I don't know if he's going to or not. That's something you're going to have to work out, and if not, bring it back in, and we'll try to adjust it accordingly. It might be that he's not able to, and we'll have to extend it out for, let's say, until Monday or something. I don't know.
Okay.
Okay. Well, talk to your attorney, sir, and we'll see what we can do. And we can always bring the matter back in for further modification. But I'm simply trying to continue to give you the addition of the time that you had, but recognizing that obviously it's mom wants to have some weekends too, or some time with the child. So,
Your Honor, can I say something?
no, you can talk to your attorney, and then your attorney can bring it before the court if we need. Okay.
Your Honor, would you like me to prepare the order?
Yes. Go
Okay.
ahead.
Could I just restate the terms so I know what I'm including? Within 7 days of today, the parties will exchange financial information. The parties will have joint legal custody. The defendant will be given alternating weekends. On the weeks in which he's not having weekend parenting time, he will have Wednesday from 6 p.m. to Friday to 6 p.m. parenting time. And he will also have alternating holidays. And I believe, Your Honor, you stated another term, but I was talking to my client and I didn't hear what you said.
Okay. The other one was with regard to the calculation of support, which would be effective the date of notice of the motion. And I've taken, of course, taken July 30, 2023 as the effective date of the support.
And you would like the attorneys to just run calculations?
Run calculations and come up with the support amount.
Okay.
Okay.
Thank you very much.
Thank you.
You remember prepare the uniform child support order?
Yes. Yep. Consistent with the ruling and consistent with incomes. Okay.
Thank you, Your Honor.
Thank you. The court will end this matter at
Thank you.
10:34 a.m. You're free to go. Court will note the appearance of Ms. Sharp on behalf of Brittany. Is that correct?
No, Mr. Roach.
Mr. Roach. Okay. I'm sorry.
No, it's problem.
With all the extra parties, I got confused. And I do note, looking through the file, Ms. Sharp, that you do have a DNA test report in this particular matter. What will happen is, I'll state, just so you're aware, is the court doesn't take any testimony on Mondays. We schedule that normally for Wednesdays at 1:30. So based upon the allegations in the petition, as well as the supporting documents, it's clear that there is a basis to proceed with an evidentiary hearing, take testimony from the parties. And so I guess I'd say, Ms. Sharp, you can contact the court and find out when you're available, when we're available for a Wednesday 1:30 hearing. Is there anything else, Ms. Sharp?
Yes, Your Honor. I don't know if the court can make any kind of decision, but the parties have been doing a certain schedule, and my client, after this case was transferred to, or actually had to be refiled in Calhoun County, that schedule, then Ms. Frew decided that she was going to try to withdraw that, and my client.
Ms. Sharp, just clarify, we have two Ms. Fews, so we clarify which few.
Caitlin, the biological mother.
Okay.
Ms. Frew, Caitlin Frew, decided that she was going to redact and try to not allow parenting time based off of what they had previously signed an agreement for. And so my client had gone a period of time without parenting time. Just recently, she started allowing parenting time, but it's really just based off of when she decides she wants to allow parenting time. I believe that it's actually hurtful to the child if the parenting time doesn't continue, where each party, they had been doing equal parenting time, and in my client with his school schedule, he was originally doing Monday, Tuesday, but he's wanting to do Wednesday, Thursday. So mom had Monday, Tuesday, him have Wednesday, Thursday, and the alternate weekends. And that has been going on for equal parenting time for a while, multiple months now.
Okay. Well, Ms. Sharp, I don't have a problem with ordering that, again, that the parenting time would continue as the parties had previously exercised.
Okay.
Let me go to, I guess, to Brittany Few. What's your response?
So me and Caitlin Fur are actually getting a divorce. I wanted to come on here and establish my rights. I do not like.
Okay, we're not going to establish your rights in this proceeding. You're going to have to file a separate proceeding then, and it'll be taken care of in that proceeding.
Okay.
This one is this matter. All this is for a revocation of paternity.
Okay.
Okay. Ms. Caitlin Few, what's your response to again the motion?
I'm in agreement with the motion.
Okay. Well, thank you. That makes it easier. Then Ms. Sharp, you can submit a 7-day order as it relates to the continuation of the parenting time and the evidentiary hearing. Contact our office and schedule an evidentiary hearing then.
Thank you, Your Honor.
Okay. Thank you all. And court will end this matter at 10:39 a.m. You're free to go. Have a good